Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the issue of fiancé visas versus spouse visas. Are fiancé visas treated the same way as spouse visas? First thing to understand is the terms of a fiancé visa, once it's issued, are different from a spouse visa. So for example, a K-3 spouse visa, which is the most similar spouse visa to the K-1 fiancé visa, it's a non-immigrant visa as well as the K-1 fiancé visa, but it's issued with a much longer duration. Once you get into America, it's not the 90 days in which to get married and then adjust status. No, you get into the United States, generally speaking, they stamp you in yearly increments as opposed to 90 days. Now, that said, as a practical matter, due to the doctrine of administrative closure, K-3 visas are not issued with any degree of regularity that I've seen in the past over a decade. Meanwhile, marriage visas are fundamentally different from fiancé visas. Those who enter the United States on a CR1 or an IR1 spousal visa enter an immigrant status. They're granted their lawful permanent residence upon entry, and basically they're good to go, except with the conditional lawful permanent residence, they may have to do a lift of conditionality 2 years down the road from their entry. Leave that aside, that's different fundamentally from a fiancé visa. Fiancés enter the United States, they have 90 days in which to get married and adjust status to permanent residence. The question being posed by this video is, are fiancé visas for purposes of adjudication of the visa application treated the same way as marriage visa applicants? The answer is yes. Fiancé visas from a legal standpoint, or fiancé visa seekers, are treated as if they are already married for purposes of adjudicating things like, for example, I-601 waivers. If you're dealing with an I-601 waiver, there is case law that says, hey, fiancés have to be treated as if they're already married to their prospective spouse for purposes of adjudication of the I-601 waiver. So from a legal standpoint, there is supposed to not be any difference when looking at a fiancé versus a spouse who is seeking a visa to the United States.